A very delightful evening to everyone. This is Janvi, currently pursuing a Bachelor of Engineering. I'm highly cheerful to welcome you all for today's webinar on the topic Intellectual Property and Effective Consulting, which is crucial for both seasoned professionals and budding entrepreneurs. Organized by the Consultants Network Affinity Group of IEEE Bangalore section. First and foremost, I would like to welcome the Chair, Dr. Aloknath Dey of the Consultants Network Affinity Group of IEEE Bangalore section, and our speaker for today's webinar, Dr. V S Lakshmi, a CDOT consultant, and all executive committee members of the Consultants Network Affinity Group of IEEE Bangalore section. Now, I would like to request Dr. Aloknath Dey to speak a few words about the affinity group and its members. Sure.
Okay, so good evening to all. I hope you can hear me and see me. So welcome to this evening. And this is 2024's first event from Consultant Network Affinity Group. I'm your chair for this year. And I must say a little bit about the history that Consultant Network in 2020, we have started in IEEE Bangalore section. But for different reasons, we could not have many programs. And I wanted to revive this even last year when I was chair for Bangalore section. We took the initiative, but it took some more time to get started. So I'm very happy to say that this year, mid-March, we had our all-member meeting, kind of AGM for this Consultant Network Affinity Group. And we formed an executive committee with 12 members. So I thank all of them and all the members to revive this and take this affinity group forward. As you know, IEEE globally, as well as Bangalore section, have many different society chapters. These are on technical themes. There are councils, there are technical communities like IoT, but then there are few affinity groups. We are very strong in Bangalore section on women in engineering, young professionals, and life members, which was also a little subdued previously, and last year we could revive it and had nice programs. This year, I see IEEE globally has made SITE as also like an affinity group. Till last year, we have been the only one having HKN as an affinity group. And now the CN, Consultant Network Affinity Group, we all are charged up to take this forward. I must say on March meeting, when we did that, we had 250 members, good number from students, graduate students, but many professional members. So that was mid-March. And before even end April, today's number is 377. So I would like to compliment all of our members, particularly secretary and the execoms, to get up to that number. And I must say already we are second largest globally consultant network affinity group after Kerala. And it is about 40 members difference. And I'm sure we will do well in numbers, but at the same time in activities. What we have done is in our meeting, we have decided to take this consultant network streams into 3 groups. Out of the 12 members, it's 4 members who are driving. One group is looking into essence of consulting, challenges, benefits, best practices, and this intellectual property, what you are going to be hearing, is stemming out of that group's activity. And so thanks, Dr. Lakshmi, to take this forward, who is leading this part and would also talk about this. The second is on the Education Institute. Now, it can be what kind of consultations they would require from outside, or as professors, what can they provide as consultant. This is another bigger topics. And in May timeframe, we were planning to have the second webinar in this from the other stream. The third stream will come in June, where it's a typical industry consultations. And we have few veterans, few coming up, some retired, some towards the end of their career, some even have chosen this as a career, and we would hear from them. I'm also happy to announce that in July, those who are here, I would invite them. Our president is visiting, IEEE president, on 21st to 23rd July, and we have fixed 23rd July, 10 a.m., a consultant network forum to discuss with him younger professionals as well as the senior professionals. So that's a roadmap that we have for at least next 3 to 4 months. So I'm very happy. I again heartily welcome all of you. Let's grow this affinity group. Let's bring value, and not just the IEEE members. This can bring even from outside. And if you know someone else who is into this business, we should be able to invite them for presentations, certain projects, activities, not just by the ECE members. We are the first to take the lead, but it's open for others to join us and to take this forward. The basic consultant network has no charge. And so therefore, if somebody is IEEE member can join. But yes, in US, there is a paid group, and eventually we might also consider, because there could be premium services, but the basic consultant network group, it's free for all IEEE members to join. With that, I thank you all and welcome to this evening. And again, give a big round of applause to all the members and those who have been contributing. Thank you. Over to you.
Thank you, sir. Whether you are a consultant navigating the complexities of intellectual property or an entrepreneur seeking to protect your innovative ideas, today's discussion promises to equip you with valuable insights and strategies. Now, I would like to request Professor Devendra Gowda, Secretary of the Consultants Network Affinity Group, to give a brief introduction to today's speaker. Welcome you, sir.
Thank you. Good evening, everyone. It's a great pleasure to introduce Dr. V S Lakshmi. Dr. V S Lakshmi received M.Sc. Engineering and Ph.D. from Electronics and Communication Engineering, Indian Institute of Science, Bangalore. Completed courses on IPR by WIPO, and completed PG Diploma in IPR Law in National Law School of India, University, Bangalore. She is consulting from since 1996 in various capacities as in CDOT. She is worked in research and development of telecom system in the area of reliability analysis, production of rural networking, and next generation networks, including routing and switching system. She is also guiding in the postgraduate and PhD students of IISc, NIT, and other universities. Represented CDOT in various forms and exhibitions. She also received Sir M. Vishwesvaraya Award for Extraordinary Contribution in Engineering in September 2011. Also received Reva Engineering Excellence Award in the year of 2018. And IET Bangalore Women Achiever Award in the year of 2021 and 22. From this introduction, I welcome you, ma'am, and take over the webinar. Thank you.
Thank you very much, Professor Devendra Gowda, for that introduction. And I would also like to thank Chair Dr. Alok for giving an insight into the affinity group. So let me share my presentation here. Yeah, please let me know if you all can see.
Yes, ma'am.
Yes, ma'am. It's visible, ma'am. Please go ahead.
Thank you and welcome to the first professional development webinar series of the Consultants Affinity Group of IEEE Bangalore section. And this is a brief about our Bangalore section Consultants Network Affinity Group. And we have the following office bearers and execom members. This is a list. I think it's on anyway, we'll be sharing it later. You can always take it. And we have about 12 members and we have the office bearers also. So some of the objectives of our affinity group is, as even Dr. Day elaborated, to foster and promote the interests of members with respect to the business of providing professional and technical consulting services, to maintain, publish and distribute a directory of members, the consulting services offered by each. Some of the consultancy groups across the globe are doing so, and to arrange for and provide technical and management talks, tutorials and special seminars and workshops on subjects of interest to members of professional development. So this is what we are going to try doing today, and also to provide a networking forum for personal interaction through meetings, social functions and other events. So today's intellectual property and effective consulting talk will be unlocking innovation, protecting ideas. This is your partner in intellectual property and strategic consulting. One request, anybody could stop me in the middle for any queries, any questions, and I would like to answer them. So the presentation basically will cover various aspects of IP management, including strategies for safeguarding IP, manage litigations, prior art searches, crafting claims and mapping claims to standards. I'll be just touching upon that, and we could do a detailed one at a later point of time. These insights will equip IP consultants to assist businesses in efficiently managing, safeguarding and leveraging intellectual property assets to achieve strategic objectives and stay ahead of the curve, driving growth in the IP consultancy industry. So types of intellectual property, patents, trademarks. I just brushing. These are all of you must be knowing it. I'll be quickly going through these things. The types of, all of us know that we have patents, trademarks, industrial designs, copyrights and related rights, layout designs of integrated circuits, trade secrets and geographical indications. So a brief overview again. What we have on the left is the legal right and the center is what for it is done and how is it done and some pictorial representation. So as all of us know, patents, they are all for what for they are for the new inventions, and how is it done? It is done by application and examination. Copyrights, basically original, creative or artistic forms, exist automatically and also it can be registered. Trademarks, distinctive identification of products or services, use and or registration, both are possible.
Ambarish, you
Registered
could
designs,
mute it, Ambarish.
Okay.
registered designs, aesthetic or decorative, application examination. I'll also be briefly explaining each of them. And also trade secrets. They are valuable information not known to the public, and we need to have reasonable efforts to keep them as a secret. So even before I embark on to understand what are these IPs, let us understand the reasons for patenting. So many of us, we would like to patent for various reasons. All of us may not have the same reason. So some of the reasons are like this: prevent copying. Almost in products, 96% of the time, they go for inventions because uh, it will help prevent copying whatever we have done. And also 78% of the processes. Patent blocking, 82% and 64%. Prevent suits, 59 to 47%. Use in negotiations. Many times it helps in negotiations. If you have a patent, you can, when especially in mergers and acquisitions, there's a lot of advantage of having patents and it can be used in the negotiations. And of course, enhance reputation, branding and other things. So all of us know patenting helps a lot in branding the companies. And of course, licensing revenue, once you can commercialize your patent, you can start getting money and start revenue generation through licensing, and also measure performance by having these patents. Large portfolio of patents of various scope. See, basically, the other strategy which most of the people would like to do is the defensive patent strategy. Say, for example, protect products from copying. Say, many a time we may not be really interested in commercializing, or we may, say, for example, academic institution would like to see that they have the idea and they want to go for patenting, but commercialization, maybe somebody else could do it by licensing. So the idea is to go for a patent so that it's a defense, so that you are protected, so you are not infringing somebody else's, or so that and also cause the competitor to design around, reduce the risk of patent infringement sued by the competitors, and cross licensing market entry is a good way of going for defensive patent strategy. This is a patent codex, which I thought maybe a good thing to tell for the younger generation. It's sort of an ethics. Do not steal ideas. Involve everybody who contributed to the idea. Do not get listed as an inventor if there has no contribution. Do not disclose your idea to others before it has been submitted. So be careful while discussing in forums, and be honest with investigative when assessing prior art and other patents. Be friendly and polite to reviewers and other authorities. Many a time, when we have an invention, it's like a newborn baby. We want to really take care of it. But if somebody points out that this is already existing, or you have to work it around, so it may be true because the prior art exists. That is why the answers are coming like that. So be very polite and with the reviewers and work on it. So let me start talking about briefly in detail about patents. So what is a patent and what can be patented? Patent is, all of us know, it's a limited right granted by the state to an inventor in respect of an invention to exclude any other person from practicing the invention. That is manufacturing, using or selling the patented product, or from using the patented process without due permission. Inventions in all fields of technology, whether products or processes, they have to meet the none test below. We call it the none test so that we can go through our invention and follow this: novelty, usefulness, and non-obviousness. Novelty is an invention depends upon the state of the prior art, that is the existing knowledge and similar inventions already known in the particular field. There will be no novelty if there has been prior art publication or even prior use. So for example, we keep seeing in academia and other places and in most of the even industry that there is a lot of publications which happens. So once a technical paper is published in a journal or presented in a conference, it cannot be patented even if novelty exists, as it becomes a prior art. However, Indian Patent Office gives a grace period of 1 year to file the patent. So we could, in spite of publication, we can still go ahead and file a patent if there is novelty within 1 year. Hence, it is a suggestion that it's good to check for novelty prior to the publication and apply for a patent either with a complete specification or a provisional specification. So this is a good point for many of the, consultancy. This is one of the good areas to work on. So you can help people to find if there is any novelty in their publications and go ahead and file the patents. Usefulness, the invention besides being new and non-obvious must also be useful. And if the invention cannot be put to any beneficial use to the mankind, it cannot be patented. So some examples like a ghost catcher. It's very weird. A method for preventing the increase in ultraviolet rays associated with the destruction of ozone layer by covering the whole surface of the earth with an ultraviolet ray absorbing plastic film. So it really needs to have a proper application. Non-obviousness, the invention must be non-obvious to a person skilled in the art to which the invention relates. Example, a patent for a new type of antenna structure that improves signal reception and transmission in mobile devices or base stations. So the non-obviousness might arise from a unique geometric configuration or material composition that significantly enhances antenna performance, which is not known to the person skilled in the art. Let me take some gross examples, like there is a software person and the hardware guy. the hardware guy goes and asks the software guy, let me know if this is novel. So obviously he will say yes, because he is not aware. So he is not really skilled in the art. So only people who are skilled in the art or the domain experts can say whether there is novelty. So these are some of the things, non-obviousness. This is a very important step we need to have in order to go for filing a patent. Some of the exclusions from patentability in India, this is a very important list. Naturally occurring substances, diagnostic, therapeutic uses, plants and animals, other than microorganisms, essentially biological processes for production of plants or animals, invention whose use is contrary to public order or morality. This is very important. Ideas, methods for business, playing games, performing mental acts, inventions which are frivolous or which claim anything contrary to the established natural laws. So in India, ideas, methods for business, playing games, performing mental acts cannot be patented. So, so these are some of the things which we need to keep in mind. An invention whose use for which contrary and injurious to public health is not allowed to patent. Mere discovery of a scientific principle, a new property, or a new use for a known substance cannot be patented. For example, you combine two items like an umbrella with a torch, then you combine it, but they two exist separately. So you cannot have a patent for them if you put together. So two new use of known substance cannot be combined in order to get a new effect. Method of testing applicability during a manufacturing process, and a method of agriculture or horticulture is not patentable, and also an invention relating to atomic energy is not patentable. So who can apply for a patent in India? The inventor, whether a citizen of India or not, the legal representative of the inventor, like an IP attorney or a patent agent, the assignee of the inventor, example, I have taken C dot. The inventor may make an application either alone or jointly with another, or he is their assignee or legal representative of any deceased inventor or his assignee. So whatever points I'm talking, they are all relevant to the IP laws in India. I'm not touching upon other countries. Patent Cooperation Treaty. The Patent Cooperation Treaty is an international treaty administered by WIPO. The PCT makes it possible to seek patent protection for an invention simultaneously in a large number of countries by filing a single international application with a single patent office. The receiving office could be Indian Patent Office. I think past 5 years, I think they have been designated to do the um, examination. The PCT system simplifies the process of multinational patent filings by reducing the requirement to file multiple patent applications for multinational patent rights. So once a single window application, and there's a lot of optimization, there's a lot of cost effectiveness while we do this. And once we get the ISR, the report, then we can decide whether it is worth filing in other countries. And based on our goals and the amount of funds we have, we can think about applying for the patents in different countries. And PCT route is all comfortable. Sorry. Any question? Yeah. So what am I saying? So when we can decide whether we want to go it for the application in other countries. If it is more than 3 countries, it is worth going through the WIPO channel. Otherwise, it is better to go for individual countries filing. So filing of a patent for an invention is similar to planting a tree today and reaping the fruits after a few years. This is what it is about the patents. So any questions I can take? Otherwise, I'll move on.
Yeah, not yet, ma'am. Please go ahead.
Yeah.
Good evening. This is Prashant. Hello, good evening. Can you hear me?
Yeah, Prashant. Please go ahead, Dr. Prashant. Yeah.
No, I just was greeting all of you. Good evening.
Okay. So let us move on to trademarks. I'll quickly, I think I'm running out of time. So Yeah. So, sorry.
Am I audible?
Yes.
Good evening, ma'am. I just have a question on patents.
Yeah.
So, like you mentioned that there are exclusions that in India for patents. So, do we have any exclusion for software patents also? Because that was not discussed.
Software patents are not patentable in India. I'll be coming to that shortly in copyrights.
Sure.
So, what is a trademark? A trademark is a distinctive sign, as all of us know, and it identifies certain goods or services as those produced or provided by a specific person or enterprise. And the system helps consumers to identify and purchase a product or service because of its nature and quality indicated by its unique trademark, which meets with their needs. So basically, it is all how the looks, how the person looks at it and thinks that this is. If I see this car, I know it is Maruti. If I see it, if I see this Godrej Almira, it is Godrej. And now all metal Almiras are called Godrej Almiras. So that's what it is. So why I'm not able to? Okay. What kinds of trademarks can be registered? So the possibilities are really almost limitless, and trademarks may be one or a combination of words, letters, and numerals. State emblems, official hallmarks, emblems of intergovernmental organizations cannot be used as trademarks. For example, you cannot involve the picture of our Indian flag into something and take a trademark. That's not allowed. So let us move on to copyright. So copyright protects literary and artistic works. All books, lectures, dramatic and musical works, choreography, cinematography, drawings, paintings, architecture, everything would be uh, sculptures, photographs, and including computer programs. So these are protected by copyright. So this is an automatic right created with the creation of work and no registration is required. So all computer programs are copyrightable in India and not patentable. So what are the exceptions to the copyright? Free use or fair deal, we call it. Quotations for commentary, illustration for teaching. So if a teacher takes some information from the textbooks and teaches the students, it is fair use. It's considered as fair use. And current news reporting, etc. Free use is also decided by the amount of work used and its economic implications to the rights holder. And the mention of original author and source is always a must. So be very careful, especially when you are publishing or anything. You have to acknowledge the author from whom you are taking any graph or a pictorial representation or any of the information. Geographical indications, this is a sort of an academic interest. So there is a registry available. So it is many goods possess their peculiar properties due to their geographical origin. GI is the best method to indicate the geographical origin of goods and services. Many agricultural products, dairy products, they all have the GI. And GI is not owned by a single owner, and any producer in the region can use the GI on the product provided it is prepared by the norms set out for the use of that GI. For example, the Mysore silk, or if you take even now, even Madhur Vada is done as GI. So there are a lot of GI available, and it's very interesting to understand them. And there are a lot of new ones getting added to the GI registry. And I think in Karnataka they have crossed almost 600 mark. I think in India we have crossed 600 mark of GI. So the registry is always also available, and it's also maintained by WIPO for worldwide protection. And it is also an offense to use false GI on goods. Industrial designs. This is another very important IP. The ornamental and aesthetic aspect of an article that enhances visual appeal and differentiates products. The 3D features or the 2D patterns of lines, shapes, and colors on a bedsheet all could be industrial designs. So, what is the criteria for protection? Not contrary to public order or morality. The shape should not be determined merely by the functionality of the good. New and original, capable of mass production or application on an article of utility. See, these are the criteria for industrial designs. Also, the functionality of suppose we are taking a industrial design registration for, say, for a bottle. So it can hold water, it could hold oil, it could hold anything, but the functionality is not protected. It is only the looks, how it is, only the aesthetic part is only protected in the industrial design. So this is very important to be kept in mind while going for design registrations. Integrated circuit layout designs. This is a sort of a layout of transistors and other circuit elements, especially people who are in VLSI, and they would appreciate this. And IC layouts, as you know, are all creations of human mind. And there is a lot of investment of time and money in the creation, but copying is very, very cheap. So that is why they brought out this particular protection. It's a special protection, and it's a fertile area with new circuit designs made every day to cater for the miniaturization and novel applications. There may not be novelty, so cannot be patented. Copyright protection does not return the investment since commercial life of a design is very limited. So it is all 10 years only. So maybe it can be extended up to another 5 years. So this is how the layout designs are protected. Trade secret, as all of us know, Coca-Cola is the best secret kept till date. And some inventions, data information cannot be protected by any of the available means of IPRs. Such information is held confidential. And trade secret can be an invention, idea, survey, method, manufacturing process, experimental results, chemical formulae, recipes, financial strategy, client databases, etc. All these could be trade secrets. Generally, when do we prefer trade secrets? When an invention is not patentable, that is one way. Patent protection is, as all of us know, is only 20 years, while the secret can be kept sort of forever. For example, if you take Coca-Cola, it's a very, very long journey. So when cost of, and also many a time when cost of the patent protection is really prohibitive, people want to keep it as a trade secret. So these are some of the examples: PCB layout, architectural designs, source code, automotive, mechanical, and there are a host of things available. Any questions so far before I move on to intellectual capital management challenges? So far, I just brushed through the basics. Okay. So complexity, IP laws, and what are all the challenges when we meet? So, I can see some question. One second. Can I answer the questions in the end because they're all coming up and going away?
Ma'am, at the end, we are having QA session. So
Okay, then I will hold on till then. So I will
Yeah.
go ahead. Yeah. So intellectual capital management challenges. So there are, we have a few challenges when we do the intellectual capital management. What are they? The complexity. For example, the IP laws and regulations can be intricate and differ between jurisdictions, requiring expert knowledge to navigate effectively. For example, the IP laws across countries vary. So we need to know the laws of each country in order to provide a proper application. How do we go about managing the IP in that particular country? Valuation, determining the monetary value of IP assets can be really challenging, impacting decisions relating to licensing, sales, and investments. This is a very, very a good area, I think, for the consultants to think about, because the valuation could be done in various methods. So and there's a lot of what do you say openings, and a lot of people are looking for help in this particular area. Globalization, as businesses operate across borders, managing IP becomes complex due to, as I told, even in the first procedure, of differing legal systems and cultural norms. Cyber security, protecting digital IPs from threats and unauthorized access is a growing concern. So this is a new ball game altogether. We need to work on it. Balancing act, businesses must balance the need to protect their IP with the desire to share and collaborate with others in an open innovation environment. So some of the things which the IP consultants can ease, some of the challenges are given below here. A lack of the challenges are like lack of IP awareness and education. So overcoming a need for more understanding about the importance of IP among employees and stakeholders becomes very important. And example, employees unintentionally share sensitive information without recognizing its value. So here is where the consultants could help in giving lot of awareness programs in various organizations and ensure that um, the sensitive information is not shared without knowledge, and enough care is being taken. And inadequate IP policies and procedures. So IP policy is a very, very important aspect for every organization, academia, or whoever it is. So, so that is some sort of a guideline for anybody to follow. And clear guidelines for IP creation, ownership, and protection are necessary to avoid confusion. So, absence of a policy dictating who owns IP when employees collaborate on a project becomes very important. So here is another very a difficult IP policies. Now templates are also available with NRDC, CPA, CPAM, and a lot of places it is available. And most of the academia and industry are having IP policies, and we can always look up one of them and create one for your own. And complex IP valuation, determining the value of IP for licensing, sale, or financial reporting can be really challenging. And valuing a unique software algorithm for licensing purposes in a rapidly changing market is really a bottleneck. And rapidly changing technology landscape. Keeping IP relevant as technologies evolve rapidly requires frequent updates and adaptations. And adjusting a patent portfolio as new advancements reshape the industry's technological landscape. So many a times, this is where we try to pool our patents, like we want to take it up as a like if you want to collaborate, you want to do cross licensing, and always keep up to date the patent portfolio in the changing technology landscape. Global IP protection, navigating different IP laws and regulations across multiple jurisdictions for global operations. Many industries, they do a lot of export, they do also an import. In both cases, you need to know the laws of both the countries before you try to do the marketing or any businesses. Filing for trademarks and patents in various countries while adhering to legal requirements. So the filing of trademarks or copyrights or industrial designs varies with every country. So when you step into that country, you have to look into their norms and their laws before you jump into the business aspect in that particular country. So this is where again IP consultants can be of great help. Continuing, IP infringement and enforcement, detecting and addressing unauthorized use of IP through legal means can be really time consuming. So pursuing legal action against a competitor who copied your product design without permission. So this is, it is very tough, but it is sometimes it is possible, and that's where the litigation start. So managing IP portfolios, organizing and maintaining a portfolio of diverse IP assets for strategic management. I think that is similar to one which we discussed earlier. Ensuring timely renewals and maintenance of trademarks, patents, and copyrights. This is a very, very important aspect in many companies. They sort of, if they miss the bus of renewal, and if there is a litigation, and once there is no renewal, the whole patent is getting into the public domain. That means anybody is free to use. So even at that point of time, even you cannot have any fights or any litigation because it's already in the open domain and the renewal has not been taken care. So this is a very, very important aspect for especially people who are in the IP facilitation in any organization. Data security and cyber threats, protecting digital IP assets from cyber attacks, data breaches, and theft by malicious actors. So preventing hacking attempts aimed at stealing proprietary software source code is very, very important. So this is another aspect altogether. Again, there are a lot of expertise available with the consultants who can help in this. Third-party relationships and collaborations, ensuring that partnerships and collaborations don't compromise IP rights and confidentiality. So drafting solid agreements to protect IP when working with contractors or collaborators, especially when you do work for hire. You may give a module to even an academic institution. to develop and then give back the module to you. They have to maintain certain amount of confidentiality. So, and also the agreements have to be very, very clear. The IP belongs to whom, whether it is a joint, and all these have to be brought out very clearly. And this is another very important area where a lot of help can be got from IP consultants. So, advantages of good IP management: optimizes asset value. Proper IP management identifies values and utilizes IP assets to their full potential. It also protects investments. Organizations invest significant resources in creating and developing intellectual property. So, effective IP management safeguards these investments by preventing unauthorized use, infringement, and misappropriation. And also drives innovation. By managing IP assets strategically, organizations can promote a culture of innovation. Clear IP policies and procedures encourage employees to generate new ideas and inventions, knowing their contributions are protected. Advantages, some more advantages: enhances market positioning, especially the trademarks and branding can be essential for differentiating products and services. Proper management ensures consistent and effective use of these assets to build a strong brand identity. Enables strategic partnerships. A very well managed IP assets can facilitate collaborations and partnerships, and also here is where you can even think of cross licensing. And sharing and IP and licensing IP can lead to synergetic alliances that drive mutual growth and innovation. Also, mitigating risks. Managing IP helps identify potential legal risks such as infringement claims. A comprehensive IP strategy includes risk assessment and mitigation plans, reducing the likelihood of costly legal disputes. So, this is a very, very important aspect, especially we want to mitigate the risks. So, how can firms increase the intellectual capital? So, this is, I'm sort of changing gears here. So, what is the approach we can have? So, innovation and idea capture. How do you increase the IP productivity in an organization? Encouraging employees to submit new ideas and inventions and assessing their viability. On the right, I have a real world examples. Google is almost 20% of the time policy for employees to work on personal projects led to innovations like Gmail. So, IP policies and education, establishing clear policies regarding IP creation, ownership, and protection, and educating employees. So, IBM provides IP education and resources to employees to promote responsible IP practices. So, these are all sort of a culture development in organizations towards IP. IP audits and portfolio analysis regularly assess the IP portfolio value, strength, and relevance for strategic decision making. So this is where again a lot of IP consultants have a lot of experience in doing IP audits. So like for example, you have a portfolio of 1,000 patents. Do you want to channelize into a pool, or you want to do a cross license? Do you want to stop some of them and put them in the open domain? So these are some of the things that IP audit will give a clear picture as to what you need to do. Especially Microsoft conducts IP audits to identify underutilized patents and optimize their portfolio. So there are different strategies being used by different companies while doing IP audits. IP strategy development, creating a comprehensive plan that aligns IP assets with business goals and competitive strategies. And the real world example is Apple's IP strategy includes rigorous patent filings to protect its innovative products. IP protection and enforcement, taking legal action against infringers and enforcing IP rights to prevent unauthorized use. So Nike vigorously protects its Swoosh trademark against unauthorized use in the sportswear market. So we can also see that the strong trademark is also a very strong IP protection. Licensing and commercialization, licensing IP to third parties for a fee or partnering to bring innovations to market efficiently. So all of us know a lot of telecom companies do that. Qualcomm licenses its mobile technology patents to manufacturers, earning royalties on each device that is sold. So trade secrets protection, implementing security measures to safeguard confidential business information from competitors. So all of us know it's a Coca-Cola. Excuse me. So employee agreements and NDA. Using contracts and agreements ensures employees don't disclose sensitive information to competitors. So especially Tesla's employment agreements includes a very strict confidentiality clauses to protect trade secrets. When we talk about international IP management, navigating IP laws and regulations in different countries to secure global IP protection. So all of us know McDonald's registers its trademarks and branding in various countries to maintain a consistent identity. Open source contribution and collaboration, engaging with open source projects to contribute and collaborate while adhering to licensing requirements. So Microsoft's contributions to open source projects like Linux demonstrate collaboration support for the community. This is again a very, very important area where there is a lot of consultancy is available, and there is a lot of misconception about open source and freeware and stuff like that. So I think there are a lot of consultants who can really help in understanding these contributions. So just a touch upon the patents and standards. So patents and standards serve common objectives insofar they both encourage innovation as well as diffusion of technology. And in order to produce a standard compliant device, use of certain patents is required. And the main requirement for using a patent is obtaining license from the owner of the patent concerned. So these are, and a patent that protects technology that is essential to comply with the standard is called standard essential patent. So nowadays there's a lot of buzz about standard essential patent. So one can always read up these things. And standards organizations therefore often require members to disclose and grant licenses to their patents and pending patent applications that cover a standard that the organization is developing. So participating in SDOs and other forums is how you can work on the standard essential patents. So just touch upon what we are doing at CDOT. It's a CDOT Gita, we call it Gateway to IPR in Telecom Arena. So we have an office memorandum that we need to be the nodal IPR facilitation agency and patent portfolio creation management in India. The need of the hour is to optimally use the existing capability. We have a lot of startups, MSMEs, domestic industry, academia, and government is to increase the patent portfolio. And so also agencies are promoting filing of patents in the country by promoting awareness, hand-holding, commercializing, etc. We may be losing out a lot of innovations and invention due to publications in journals and conferences, which has been the main interest in academia, and possibly a relook at that could help us to increase the IP productivity in the country. How do we overcome the challenges of SEPs in the country? So here we have creation and management of patent portfolio and sort of move some of the patents or a pool of patents into the standard essential patents, and by participating in global SDOs and making a lot of contributions. And of course, IPR management policies and licensing, negotiations and conflict resolution. So small pilot which all IPR cells of colleges can try, identify the publications, say for example, the last 1 year, look for patentable matter with IP attorneys or IP consultants, a committee to evaluate these potential patents or their novelty, and facilitate the authors to file the patents, and participate in SDO like TSDSI, IEEE standards, 3GPP, etc., and declare the SEP, thus converting patent into SEP. It looks very simple, but it's not that simple as such. So I would also like to touch upon the National Digital Communication Policy, envisages to enable next generation technologies and services through investments, innovation, and IPR generation. The objectives include creating globally recognized IPRs in India, developing SEPs in the field of digital communication technologies, promoting Indian IPR through international collaborations. So we are just 1 day behind a World IP Day. Tomorrow is the World IP Day. I wish all of you a very happy World IP Day tomorrow. And the theme of this year's World Intellectual Property Day is IP and the SDGs, the Sustainability Development Goals, building our common future with innovation and creativity. So almost 1 in 3 active patent families worldwide are related to the SDGs. On analysis of patent trends reveals that some SDGs like SDG 9 Industry Innovation Infrastructure and SDG 13 Climate Action exhibit substantial patent alignment, showcasing significant innovation activity. However, certain of the SDGs focus primarily on socio-economic aspects have limited patent connections. So I thought this is one of the relevant ones, so I've just added this in my presentation today. I would like to thank Consultants Affinity Group of IEEE Bangalore section, especially Dr. Alok Nath sir, for giving me an opportunity to present here. And thanks to Professor Devendra Gowda, Secretary, for his patience and support in handling this whole presentation. Thanks to CDOT and IEEE. Thank you very much. So I'm ready to take questions.
Ma'am, if you have questions, ma'am.
Yeah. Can I look at them somewhere?
Yeah, Devanathan, Dr. Devanathan is asking, how do emerging technology like AI and blockchain impact the patent filing process?
Yeah, that's a good question. Are these in the chat box, sir?
Yes, ma'am, it is in chat box only.
Okay, I opened the chat box. Okay, let me start off from the beginning. Okay, how do emerging technologies like AI, blockchain impact the patent filing process? Yes, of course, in India, it is very difficult to file any patents in AI or blockchain. But if you have a hardware attached to that, possibly there is a possibility to do that. This is a totally a different aspect altogether. Of course, there are patents existing in blockchain. AI is an evolving field, and there's a lot of discussion going on. But as of now, in US and other places, that it is still patentable, but in India it is not. So that is a situation. So maybe you could look up at WIPO, which gives a lot of information on how AI patents are protected. How industrial design, how can we say it's novel? Oh, you have to, there is a prior art search even for industrial design. So you have to, you can go to any attorney. I think there are design registrations are also having a database where they take your design, check it out if there is novelty, and then only you can go for filing. Yeah, there is some sort of a prior art for that also. Automatic copyright. Can new algorithm software be copyright? Yes, it can be done. Yes, all these are copyrightable, no problem. And what kind of layout designs are patentable? How to know it can be patented? Again, same thing. You have to do a prior art search and see if it is patentable. First of all, layout designs are not patentable. They have a specific semiconductor layout design. It's a special protection. You can go for that. It's not patentable. When a copyrighted book takes the shape of an innovative institution, when a copyright takes the shape of an innovative institution, can the latter be? Not really, because the book is already published and it is already in the public domain. That means to say there is already a prior art. So if a prior art exists, the institution cannot be. There is no patentable matter in the innovative institution. But of course, we can look at other IP like trademarks and design may be possible. But there is definitely no patentable matter as such. Patent expert issues, layout designs. I didn't understand the question. If AI is used as a tool to assist the creation of work. Yeah, this is a gray area. I too do not know. That's the reason I have asked you to please go through the WIPO documents, which give a lot of information. And maybe I'll come back to you on that. What are the courses to encourage students to? Yes, a PG diploma in IPR Law from NLS, and there is NALSAR, and also the WIPO certification is a very good one to start with, but you have to be a degree holder if you have to take that online course. An individual working in an organization, can he file patent if his organization disagrees with him or see no value? That is the agreement between you and your organization. So if you take C dot, we would not allow something, any technical thing. If C dot does not agree, it is not allowed by him also to patent. But if, say for example, he has written a poem, he can take a copyright for himself because it's no way related to what we do. Yeah. And if my answers are not okay, anyone who has asked these questions can ask me further, and I'll be happy to answer. Yeah, Purnima, I think you raised your hand. Purnima is unable to unmute. Maybe you can put it in the chat box, your query.
Okay, now I
they
can.
Okay.
Yeah. So like in the line with the, we have question on AI blockchain. So in the similarly in the field of IoT, so even though the changes at the cloud may be purely software, but they may impact the devices in a huge way. So is it possible to patent ideas which impact the devices indirectly?
Yes, yes, yes.
Okay, okay. Thank you.
So if there are no other questions, let's conclude it.
Janvi, go ahead.
So I request each and every one of you to turn on your video camera so that we can take a screenshot for the documentation.
Yes.
Thank you.
Yeah.
Thank you, and see you all in the next webinar that we'll be hosting in May timeframe. That'll be more on the educational institute and how we can bring consultancy there. Thank you.
So sure, we have a small gratitude to for ma'am. So as we draw this insightful webinar on intellectual property and effective consulting, so I would request our host to share the virtual memento on behalf of Consultant Network Affinity Group of IEEE Bangalore section. I request today's webinar speaker, Dr. V S Lakshmi, to accept a small token of gratitude.
Thank you very much. Yeah, thank you very much.
So I extend my sincere gratitude to every one of you who joined today. I would like to express my deepest appreciation to our esteemed speaker, Dr. V S Lakshmi, whose expertise and passion illuminated our discussion and provided invaluable insights. Thank you, one and all.
Thank you. Thank you very much.
Bye.
Thank you, everyone.